All right, we are back in Senate Judiciary. It's May 7th. We are here with lead counsel to talk about a small change, page 105.
Yeah, I'm just logging in right now. But in the meantime, for the record, Ben Novogroski from the Office of Legislative Counsel. Here reviewing draft 1.2 of proposed amendment to H105. Based on the discussions from last hearing, there was a request to ensure that the form that the notice of violation is memorialized on has room to indicate any substances that may be detected or in possession of the person in the incident, but without citing them for more than one. So that language can be found on page 7, and it's highlighted. So you'll see in subsection B on lines 9 and 10 that you'll see the additional language that's already been present, that a person shall not be cited for more than one violation of subsection A. That language goes on to say the notice of violation shall require the person to provide the person's name and address, shall indicate the presence of any substances that constitute a violation of subsection A of this section, and shall explain procedures under this section. So the wording presence of substances could be those within someone's body or those that are present in the vehicle or on their person.
I don't want to nitpick here, but would we not want it to be presence or possession, just to make sure we're covering that base of, if it's in the car?
Well, there's possession, there's procurement, there's misrepresentation of age. The substances though that make out the violation are of alcohol or of cannabis, or on the form itself, buprenorphine. So if you want to be more specific, that's absolutely your prerogative. I guess it was an attempt to sort of streamline it in one term without making it too clunky.
I mean, if it confuses the issue by putting possession in, then I would want to avoid that, but
I would defer to the court administrator and anyone else, practitioners that may have better insight into how that would be interpreted on the day-to-day.
Yeah. Okay. Thank you. Any questions for Ben? Or I'm sorry, did you have more?
Well, so this morning, court administrator reached out with some comments from hearing officers and other folks in her office, and it was brought to my attention that since specifically 23 VSA 1216, which creates that 0.02 violation for alcohol, and it's being moved to Title 7 in this, that some of the defined terms in Title 23 should probably carry over. And so that might be a consideration for the committee to either add a definition section of specific terms. So I did a quick review this morning of operated, operated, or is in actual physical possession, what a vehicle is, what a highway is, license to operate a motor vehicle, privilege to operate, suspension of license or enforcement officer. So you can do cross references in Title 7 in this section to those terms in Title 23. You could also draft an intent section that essentially explains that all terms that are referred to in this section shall have the same meaning as they're defined in Title 23. Another suggestion that was provided by one of the folks that sent it to the court administrator was keeping 23 VSA 1216 in Title 23. The only and that's your prerogative as well. The only policy consideration that I know was sort of at play through testimony was streamlining the statutes and the process so that they're all in one place and you don't have people think they've completed one thing when there's still other requirements hanging out there because another statute governs. So it can be done in either of those ways based off of your preference.
I mean, my personal preference is always to make things a bit more streamlined, both for the individuals going through the process and also practitioners. But do you, I mean, this might be a question for Terry, but do you think that just cross-referencing Title 23, 1216 is the most straightforward way to go?
Well, you'd have to, not the statute itself, but the definition statute, which is 23 VSA section 4.
Oh.
So I think you know, a way to do it that would work is in the proposed language here, create a definition section is cross-referencing those specific definitions in section 4 of Title 23.
Back and forth with them. Sarah Mouse, you have your hand up?
This just gets at the
Form.
yeah, the thing I brought up the other day on the road bill.
Right. Yeah, exactly.
I think the concern, if I remember correctly, was I think there were a few of us concerned about making sure that the program is aware of the possession or the use of other substances, since there's only one citation being issued, instead of having to issue multiple citations. But yeah,
Yeah, I believe the testimony was that, you know, giving the providers and the program as much information as possible, because just because you're cited for one violation doesn't mean you can't be treated or rehabilitated for just the basis of that one violation, if I'm recalling correctly.
so I'm good with cross-referencing Title 23, Section 4 for the definitions, unless anybody has strong feelings about not doing that.
And Harry can probably speak more in depth to the concern, so, right.
Any last questions for Ben? Okay, thank you, Ben.
Morning, everybody. Good person, city court administrator. Nice to see you all. And I can start with the first item that Ben mentioned, and that was from hearing Officer Charles Romeo just kind of phrased the question. You're lifting the underage DUI component from Title 23 into the new section. All the references are as defined in this title. He was talking about that, but Ben explained that his approach would be to take the operative phrases that would be subject to interpretation and defining them or referencing the definition of section in Title 23. I think that would address hearing Officer Romeo's suggestion. So, and he's happy to, if you'd like to, with the draft, review it and review pieces from his experience, you know, where questions might arise. So that would be helpful.
That works for you.
Otherwise, I was asked specifically whether or not it was possible to, we have a couple of the court administrators office, a couple of form responsibilities under the new amendment. And I thought I would just go through each one and let you know in terms of what we got. Although I do have a question in terms of the substances. It talks about in the new language, and this is on page 7, lines 9 to 11. Shall it's a notice of violation. That notice of violation form already exists. We've prepared one in the current statute, so it would be potentially modifying it, but it indicate the presence of any substances that constitute a violation. Currently, the notice of violation form makes reference to minors misrepresenting age, which is not charge. Possessing or consuming alcoholic beverages. And alcoholic beverages is kind of a blanket that is used to cover the very specific references to malt or venison beverages, ready to drink spirits, beverages, spirits, or fortified wines. Did you want the notice of violation to be as specific as the type of alcoholic beverage, or what is the?
I don't think they need to. I don't think we need to differentiate between wine or liquor. Not necessarily.
Presently, it says alcoholic beverages, and then cannabis. We can add that sheet should we like to make it that specific. That was happening.
I mean, personally, I don't think it needs to be that specific, but
Okay.
if the committee has other thoughts.
Are they separate charges? Like, could someone be charged with a hashish charge versus a cannabis charge?
Either one.
So they are separate. Oh, well, then I think we should include both.
But what this bill does is that you would only be cited for a single violation.
So you could, so what I'm understanding, you could be cited for a hashish possession, but then the sheet would say they also had alcohol, they also had cannabis. Right? That's big one.
And the charging officer, from what I understand, would select and indicate which charge, and they would, when they complete the notice of violation form, be the one to decide that.
I guess what my concern is actually not about the form, and it's about making sure we capture all of the charges that can be diverted. Or sent, not diverted, but sent to the youth substance awareness safety program. So as the bill is written now, if someone is charged with a hashish violation, can they go?
Yes,
Okay,
because
that's all I want.
it's possession and the subsection A was added.
That was my-
That's one of the forms of cannabis.
That was the flag for me, is if they're separate charges, I want to make sure they're all incorporated.
Yeah, and I can scroll up to that portion just so that you want
It's
to.
just not what we were paying attention to. So this raised that flag for me elsewhere.
That's what I heard. Yeah, so if you see here,
There it
page 2,
is.
subsection C.
Okay,
So this was added at the last hearing.
awesome. Thanks.
So in terms of the notice of violation, it may be modified, this one, if you're sure that, which we can certainly do, just wanted to clarify, would be the law enforcement officer that would be selecting the one instance. Regarding the notice of suspension, which would be a new form that we would be creating, which I assume would be similar to we have notice of suspension now for civil violations. We can certainly prepare that form and create it and include all of the different requirements that you've got listed in the proposed amendment. No problem. The addition about the confidential records, that again is something we can certainly do with any kind of court document and it's coded as whether it's public or not public. You would want to check with DMV to make sure the word aware of that, because that would be in their records as well.
I think they didn't weigh in on this. They weighed in on something else.
That's on page 13, lines 12 and 14. We're able to easily mark the records confidential, but we thought we'd just highlight the information where that change. And then with respect to the reporting requirement, where it's the Attorney General's office that has the obligation to file the report, I wanted to just let you know in terms of the data points in the report. We can provide some of it, but not all of it, just so you're aware. The number of persons referred to the youth substance awareness safety program, certainly, because we would know we'd be taking it in charge of. The ages of the persons referred to the program, we'll know it's within the 12 to 21 if this passes. But unless law enforcement provides a date of birth, we wouldn't necessarily be able to specify ages more detailed than that, just so you're aware. The number of persons who successfully complete the program and the number of persons who fail the program, we wouldn't necessarily be able to provide those data points because we're not always notified. I believe it's Willock that would probably be the ones that would be able to, that they would be able to provide that data. And then the last data point, the number of persons who served suspensions imposed by the Judicial Bureau after failing the program, we can certainly provide that data. So it's just those were the provisions that impact our office, and then the other comment that been already addressed in terms of just the kind of the logistics for the cross references.
Thank you. So I think there are a couple last steps we have to take regarding the cross reference that you just mentioned, and contacting DMV to see if they want to weigh in on the other piece that you mentioned. Then hopefully you can take this up for a vote early next week or maybe tomorrow, Senator Morris. So,
Quick question, Terry, is date of birth on that form or?
For the notice of violation, I don't believe so.
I think it would have to be on the ticket, so.
Typically, there's a space for whether it's.
Without creating sort of a mandate that can't be fulfilled. I mean, what you could do also is, in the legal language here, containing the following, if available. or something to that effect. So you're not, requiring information that isn't collected, and creating a Band-Aid that can't be fulfilled, but just wanted to put that out there for the committee.
Any thoughts on including available?
That seems reasonable to me.
If anybody opposed, put that. All right. Willa, did you want to weigh in on this or are you here for two?
No, I was just here in case questions arose, but,
Oh, thank you. I should have
yeah.
referred to you when I
Yeah,
was.
that's fine.
Sorry.
We're fine with collecting the data and we do gather ages, date of birth, if they're referred to. It's on the ticket.
Oh,
So, yes,
and then the number of persons who complete the program or fail the program.
right, we would have all that information. There's just another 5, which we would rely on the Judicial Bureau to provide.
Thank you. Any last questions prepared? Great, thank you.
Thank you.
Yeah, thank you.
Very much for the chance.
All right, so- Good. Next up, we have H222. And Kim McManus, she on. So she was here earlier. Yeah, no, actually, 5 months tomorrow, that would be. Awesome, thank you.
Did we observe witness?
Yeah, I think, I'm gonna peek my head out and see if Ken.
I think it
is.
So you don't know that.
Yeah.
It's possible if they could.
You see him on the golf course. He's an Irishman.
Not the end of the world.
Get more upset at him.
That's a
Yeah,
good.
thanks. You're right.
He must be wrong.
Stay.
For the rest of it, because we're online, but now.
We're done.
It's,
I can't.
I'm not sure.
I'll
stick with things first.
Join that out. So we are still live and we are now switching gears to H222. We did reach out to the Defender General and they said they did not have a need to testify on this bill. And we do have the state's attorneys and sheriffs here to provide their perspective.
Good morning, everyone. Kim McManus, Department of State's Attorneys and Sheriffs. Thank you for inviting us in. As you all probably realize, this is civil RFAs, so not really part of our house until somebody violates and order of the court. What we testified on the house side, and we just wanted to reiterate today that we do not support that there's now a certain court order that would be a violation of protective order. That there's now, it's the start of now 2 strings of orders, some that are violations and now one that wouldn't be. We understand the reasoning, we understand the wants for education early on, potentially before something became criminal action, and the want for potentially victims of domestic assault not to go for the criminal route, but to try to work on behaviors through the RFA route. So we completely respect that and understand wanting to, I guess incentivize may not be the right word, but sort of offer enough, but with, knowing somebody could have that order without potential criminality of it. So we understand the reasoning, but we are just concerned about having 2 strings. We think a court order is a court order, and that it's violated in this context. It's something that, if appropriate, we would want to take action on, and we just wanted to repeat that here before you.
Any questions or comments?
So, Are you then suggesting a change to the bill or a?
So on the House side, we had just said we didn't think this shall not be considered a crime for any purpose was needed, but that we did not like it. So if that was removed, but we also understand again,
And this is which page?
on page 6, where it says that in order to complete domestic violence accountability program could be ordered, and it says failure to complete the program shall not be considered a crime for any purpose, including 13 VSA 1030, and that's the violation of abuse prevention order. So everything else that's potentially on that RFA, the stay away order, is not to go within 300 feet. If a person did any of those things, that's if they intentionally did not, if they intentionally committed an act that was prohibited by the court, that's considered a violation of an abuse prevention order. If somebody intentionally did not do this class, did not complete it intentionally, and there's a big difference there from life circumstances for preventing someone. If somebody's intentionally not doing it, that would be, in our eyes, a violation of the court order. Now, this is absolutely a lawmaker decision. If you all decide that that's not something that's a violation, we will, of course, respect that and follow that. But we just pointed out on the House side that we did not think this was a big road to start going down. Like, there are some that are crimes and some that are not within the court's orders.
I'm just wondering, what are some of the other conditions that might be included in that RFA? And do they all entail an element of violence?
So not all, but I think the way the court describes it is that everything else in the RFA is a prohibition. You know, you may not contact the person, you may not go within 300 feet of the person or their vehicle, you may not go to the home, you may not go to their place of business. This is now a requirement to do something versus not doing. So all those other things would not necessarily be violent.
But they could be perceived as threatening to a victim.
100%, and that's exactly why they would be part of that RFA. And the piece in domestic violence, there's usually not just one thing going on. So if somebody's intentionally not going to class, and maybe depending on the relationship, like that's being, taunted to the victim, like they can order it, but we'll see, I don't really have to do it. There's like another opportunity there. That's power and control, and there's often also everything else going on. So we just were reticent of it, and we just wanted to raise the issue, but again, it's a choice of the legislature.
All right, so I hear where you're coming from. My initial reaction is I don't, just from my own perspective, I don't fully agree with the idea of making, creating a criminal charge for failing to attend the class. I think, to your point earlier, I think, the other parts of these RFAs, not contacting the person, not being within a certain number of feet of that person. I mean, those are all aspects that could lead to another instance of abuse or, creating fear. But I think that making this requirement that a person attend a class, I don't think necessarily holding a potential criminal violation over their head for their failure to attend the class is necessary in this case, because there is also the civil contempt proceedings that could occur as a incentive to follow this order. That's my initial reaction to this issue.
And just to clarify one point, it's not failure to attend, it's failure to complete. So, often these programs, almost all the programs have a contract. The contract will say, 3 misses or 4 misses of a class, you are removed from the program. And that's what we see when this is a requirement of probation, and that's how someone will have a failure to complete. Often the programs will not let the person back in until either a certain amount of time or some sort of work is done before they're ready to come back in. So just wanted to point that out. It's not just missing a class, it's failing to
Thank you.
complete the program.
Yeah.
And again, we completely understand the reasoning, but we just wanted to state that you're not in favor of it.
Senator Ruth.
So to clarify, your suggestion would be to pull lines 7, 8, 9 to the period and then just remain silent there.
Yes, from our perspective.
Thank you.
Anything? Senator.
Thanks. I know we're gonna hear from the Domestic Violence Fatality Review Commission, and I know we also, Charlie in the room from the network, and I'd love to hear their weigh in on this, because I absolutely respect where you're coming from. Generally, I'm reticent to make new crimes, particularly for things that wouldn't be crimes unless something else had happened. And I want to hear from those who are most impacted, because I think we rely on things we've kind of always done, and criminalization is certainly one of those things. And if they're not working, I think it's worthwhile to explore other avenues. And so I do want to hear from the impacted groups. And again, totally respect for your coming from. I just don't know that I agree. But I can't make a fully informed decision yet.
Those are only comments. Okay,
Thank you.
thank you.
Carol? Yes.
Good morning.
Good morning.
I'm Carolyn Hansen. I'm the chair of our Domestic Violence Fatality Review Board and also an assistant attorney general. And thank you very much for giving me an opportunity to talk with you today. In our office, an opportunity to talk about this bill. I'm going to focus my comments on the section that Ken was just referencing, which is on page 6, subsection J. The order requiring defendant to complete a domestic violence accountability program. And I just wanted to start out by talking a little bit about why this is so important and how grateful we are that this bill is in front of you. The Fatality Review Commission in our 2024 report, we recommended that be available in final relief from abuse order hearing, that the relief to attend this kind of program be an option. It's not going to happen in every case. It's not going to happen in a lot of cases. But when the judge sees an opportunity there and when the plaintiff has requested it, it gives the judge the opportunity to do this and to be proactive. And our hope is that by addressing this behavior earlier, we can avoid exactly what you're saying, having more people have to come to criminal court, basically because they need to change their behavior and they don't know how. There are an awful lot of people out there that have grown up in households where this was just the way business is done. And just simply telling them, don't go near that person, don't call them, that spirals them, can spiral fear. Like, I'm going to lose this person and I care about them and I need to know where they are 24 hours a day. And some really troubling behaviors. And so, thinking about the fact what we know about domestic violence is it's learned behavior and it's effective, unfortunately. Power and control are effective when you use violence to enforce your power and your control. And learning a new way of being is hard, especially for people who've grown up doing it this way for a very long time. But we have an opportunity, and I'm especially excited about the opportunity for people who are a little bit younger. And maybe this is their first foray into somebody telling them that their behavior is not okay. And so it's only going to happen in some cases. And again, just to remind folks, I know you guys know this, but this only would happen after a finding by the judge that the defendant has engaged in abuse, and a finding that there is a danger of further abuse, and an opportunity for the defendant to be heard. So there is due process there. There's an opportunity for the defendant to weigh in on this. And generally, the way RFA hearings work is the court only imposes the kind of relief that a plaintiff asks for. So plaintiffs will say, I think I want to still be with this person. They told me that they want to change, and I want to see them have the opportunity to do that. And so I can tell you, for a very long time, I was the domestic violence prosecutor in Chittenden County. Almost every meeting started with, when I meet with the victim, they would say, I just want this person to get help. I don't want this criminal case to move forward. The next thing I'm going to do when I leave her office is I'm going down to family court and I'm dropping that restraining order that I got. And I would say to folks, I hear exactly what you're saying. I want to make sure that this person gets help too. We can impose it as a probation condition. I hope that you'll think about maybe instead of just dropping the order, asking the court to change it or modify it to, like, for instance, they could say non-harass. Wouldn't it be great to be able to say, and you can ask for the opportunity for this person to engage in programming before that meeting, before criminal charges even filed, is where I think this will be most effective. I know you had a question, Chair, about what would happen if both things are going on. And the judge has the discretion and ability to modify a family court order at any time. So if the defendant gets himself into criminal trouble or herself, and wants the court to modify the order, or the lawyer does, they could come in and say, Judge, this is not what we want my client to be doing right now. He's now been charged with crimes. They always have the ability to change that. But our hope is that this will be used most often without having to get to the stage where it results in a criminal engagement of some sort. And I think you also asked yesterday about, like, could people do this more than once? And I think that there's a lot of answers to that. I think it depends. If somebody's engaging in this program, we're hoping that their behaviors going to change. We're hoping that all the behaviors that they were exhibiting where they were abusing the person are going to change. And so if that's all happening, there's no need to impose any additional programming. The prosecutor could be looking for some other option there. But let's say the person's continuing to engage in those behaviors and they're not really learning. Some people need a little bit longer time to learn. So I could see there being situations where it's negotiated that the defendant perhaps does additional educational programming like that or intervention, or maybe not. But I just think that answer is going to depend on sort of what's happened since the time that the defendant first engaged in and completed the program. And hopefully they do it successfully. And most folks, I think, get a lot out of this program. I'm sorry, did you have a question?
Oh, I'll let you finish your.
Oh,
your
okay.
thought, but I do have a question, but.
Well, no, please.
And my question is about the programming and how long it is, how many classes there are. And it's sort of, the reason I'm asking is, so, I mean, everybody here knows I'm a social worker. And what I know is that a lot of times people make steps forward and steps backwards and steps forward. And they might actually they may make progress doing it once, but they haven't reached perfection. And so I'm wondering if you have data around any of that, and even attending 2 out of 10 classes might move them forward, but they might not be ready. Or do you see any of that sort of interplay with the course making some things better, but not quite where we want them to be?
I don't have data available, but somebody perhaps from the Domestic Violence Council that oversees the standards for these programs might. I know they're collecting lots more data these days than they used to. I think it's, I'm trying to think when I lost my train of thought on that, but nobody's going to, I think it's important to understand that even regardless of whether we do it the way Kim is suggesting, or we do it the way it's written right now, criminal charges are not automatically filed. I mean, right now, what happens, there's a BAPO, is a violation of an abuse prevention order, is somebody first of all has to report it. Doesn't happen automatically. There's nobody monitoring these things. So if someone reports it, the police investigate it, and then the prosecutor has to decide whether they should file this. So as Kim was explaining, if the person just doesn't have the wherewithal to do it right now, they don't have a car and it's a program they need to drive to or whatever, if that's not really a willful violation, unless they're thumbing the nose at court, which some people are, claiming that they have a lot of reasons that they can't do this. So we're already kind of looking at that when it's a criminal violation. The way this is set forth, my office testified similarly in front of the House, as to what you heard from the state's attorneys, but we're fine and we support this current version because the most important thing, and I guess what I want to say to you all today is the most important thing is we want to see this bill pass. We want to see it go forward. So whether it's civil contempt or whether it is a violation of abuse prevention order, we're happy. We're going to make it work. My office shares the concern about taking one particular kind of relief and singling it out to be done in a different way, simply because it's not simple, right? If you say, well, this type of relief is done this way, but this type of relief is done this way. It's not a deal breaker. Again, it's not a deal breaker. I have one small suggestion for you, which is if you leave it the way it is, and if it needs to stay the way it is, in order for it to pass, then please leave it the way it is. But you could insert a just after I'm on page 6 here, J, it says, but may subject the defendant to civil contempt proceedings as set forth in Family Court Rule 16. Because Rule 16 lays out civil contempt. It's really, like I'm saying this as a lawyer, but I think it's really easy to understand what the steps are that would be taken, and it at least points people like, this is how this condition gets enforced. The difference will be that if it stays civil contempt, the plaintiff has to do it, meaning the victim who may very well be really struggling to come to court in the first place, because they're fearful, has to make a motion to the court. They're the one that has to make the complaint about it. As opposed to when you have it as a criminal violation, anybody can make that complaint to the police. You know, it could be a family member saying, hey, the court told my nephew to go to this programming, he's thumbing his nose at the court and he's not doing what he's been told to do.
Just a question. So if we were to add Family Court Rule 16, was it?
Mm-hmm.
How would that, again, change, how would it change things?
It wouldn't change anything. It would just add a little bit of clarity because this is different. And I think it could be helpful to point practitioners, plaintiffs, anybody who is looking at this, what do we mean by civil contempt? Because that's not the normal way that we enforce a violation of abuse prevention order. It's important that it's enforceable. All court orders need to be enforceable. There's no accountability if they're not enforceable. And civil contempt will work, and there's a process laid out already in the Vermont the rules of family procedure. Sorry.
I am wondering if we remove that sentence that begins failure to complete program. It's one of a number of things that a court might order. Does that preserve the ability for the judge to go either route, so that the judge could treat it as violating a court order, or could treat it as Rule 16?
Generally, because violations of abuse prevention order have a prescribed way that they're handled, which is a criminal charge, that normally would take that. I believe that under the rules that would result in it being that direction as opposed to just enforcing civil contempt. But the court always has its own authority with civil contempt. So that might be a good question for Judge Zone, just to double check on what I'm saying here. But right now, what the VAPO statute, the violation of abuse prevention order statute, says is that violations of an abuse prevention order fall under this. And it also says that they can be enforced through criminal contempt. So there isn't any reference in there to civil contempt. This family court rule, it deals with where there is no prescribed way of enforcing the order. And the way it's used most right now is the divorce proceedings. So it says at the beginning of the rule, it says, you know, this rule applies when it's not summary contempt, which is somebody being in contempt of court in front of the judge, like yelling at the judge in front of me. Or when it's criminal contempt, then the judge would make a referral to the state's attorney who would then file criminal charges. It lays out a process for civil contempt. So there is a process available. And if this is a compromise, again, if this is a compromise that needs to be made in order for this to move forward, we support it. I just want to make sure that you all know that it does require a little bit more of a lift on the plaintiff. And it is treating this one type of relief differently. That's not a deal breaker. I don't think it should be a deal breaker for you all. It's just a matter of awareness.
Senator Morris.
Yeah, and then you may have missed answer my question, Carolyn. My question was going to be, other than subsection J, are there any other conditions on this relief endorsement, relief from abuse, or to have the option of being civil versus criminal? Are they all treated as criminal? Why should this be treated differently?
They're all currently treated as criminal, and there are things in there, in addition to saying like, don't go near this person. There are things in there about the judge can make provisions for instance, for care of a pet. Sometimes judges put things in those orders that say, this is how child care will happen, child supervision will happen. This is where you will drop the kids off and pick them up. And then, of course, when those things change, the parties come back before the court, and the court can always modify a relief from abuse order at any time. But there are sort of some ongoing obligations in some relief from abuse orders right now. Although, as Judge Donate indicated, I mean, a lot of it is prohibitions. Most typically the orders say, don't do this and don't do that. And just one other thing I'll mention is that, you know, it used to be that these programs required defendants, for instance, they would be asked like, what is it that you're here for? And the defendant would need to basically say word for word what they had been convicted of in order to be accepted in the program. The standards are a little different. So that's how it was a long time ago. But the DV Council revised all the standards for DVAPs and made them value-based. So we got away from the idea, we don't want people to feel shame. We want people to feel positive and be treated with respect in this programming. So it's not as though a defendant has to come in and admit to some very specific thing, but they do have to come in and they have to have something they're there to work on. I mean, if you come in and you say, I do everything right, and I'm just here because, you know, I want to be even better than I am, they're going to be like, well, you know, you're not going to really be helpful to our group. You have to be acknowledging that you're using these behaviors, but you don't have to be acknowledging that you're engaging in some kind of criminal conduct. I mean, there's usually a lot of behaviors going on that don't even rise to the level of a criminal case, but are nevertheless abusive. So
Do you have a question?
Yeah, it's more of a statement really, and I guess, you know, to the point that's been made, you know, twice now, what I see is different from most of the things on an RFA is it's not a prohibition, it's and so I do see this as a little bit different. We're not telling you not to do something, we're telling you to do something.
yeah,
And so I do see that as different.
and I think that's a perfectly reasonable way of looking at it and using the civil contempt power instead, because like I said, we've already got a system and it will work. It's just more a matter of educating, making sure everybody understands how it works, but giving defendants the opportunity with a little nudge from the court that you really need to do this. I think it could be very helpful in preventing future violence. You know, we often see people at review and they have not engaged in any kind of court process. And I think having this be something that's available through family court might incentivize folks to be like, oh, I could get an order to do that, to have my partner go through this. And we know that when people do turn to court, whether they're turning to family court, there's a protective factor in that. So I'm really excited about the possibility of this programming being able to be available earlier in cases where it's appropriate.
Yeah, I wonder, and I don't know who the right person to ask this is, you know, making this available earlier in family court is great, but if there's a potential criminal charge associated with it, does that have a chilling effect? They are not even go and ask for it because now it might end up in this criminal charge. Does my question make sense?
I don't think it's likely that plaintiffs won't ask for it, because again, when I was prosecuting those cases, they were always saying, I don't really want to see a prosecution. Now, there were cases where people had been severely injured or nearly killed, and they were like, I just want to see this person in jail for as long as possible. But that was unusual. Most of the time, people were like, this person wants to change, they're telling me they want to change, and I don't want to see this criminal case move forward. And so I don't know if I'm answering your question exactly, but please tell me if I'm not.
Not quite. So opening this up to people earlier, presently, it's only open at that higher level. And I guess what my concern is if we attach that if you fail to complete this for some reason, there's now a possible criminal charge associated. If that might actually make people who might have asked for it not ask for it because they don't want their partner to have a potential criminal charge.
Yeah, I think that's a very good point. It's a softer approach. I mean, that's the benefit of doing this as civil contempt. And the good thing is that later in this bill, it's on page something, I'm going to tell you in a minute. Okay, very end of the bill, subsection H on page 10. The bill, it requires that the Fatality Review Commission report to you all how many referrals we've received and how many people complete. So that will give us some good information, and we can always come back and let you know, hey, civil contempt isn't really working. So we'll have an opportunity to do that. We'll have information pretty soon because, I'll be doing a report again at the very end of this year. So we can certainly come back and let you know if it turned out that it just doesn't work.
I think that would be useful. Thanks.
Absolutely.
Did you have any additional testimony or
No,
any thoughts on what we've heard? Are we,
I mean, it makes sense to me to add the set forth in Family Court Rule 16 to be more clear. Like clarity, I always support clarity. So that makes sense to me. I do wonder if the network has any thoughts.
yeah, we were going to get
Okay.
into that. First wanted to ask, are people generally okay with keeping the civil contempt proceedings as it's written now and adding Family Court Rule 16 clarity?
There's a part of me that wonders about the sort of totality of the effect of that first clause. So failure to complete the program shall not be considered a crime for any purpose. Because I'm trying to imagine the worst offenders of this. And, it seems like saying that a judge can require it, but then at the same time saying it's not a crime and the person you were abusing would have to bring a civil contempt charge against you. It seems like a loophole that a certain sort of individual might, drive through. So I'm just wondering if that was the purpose of my question, if the judge could go either the criminal or the civil route in response to not completing the program. I'm wondering why I would take that discretion. Anyway, it's not a deal breaker either way.
Other thoughts?
I just say, let's be consistent. Obviously, my thought is, if the rest of them are criminal offenses, court ordered, then there should be a criminal. So, like I say, it's not a deal breaker either way, but that's my thought.
Turn Alice, anything?
Yeah, I agree with both. Senator Ruth and Norris, their thoughts on it. Again, not a deal breaker. Senator Folks.
Well, I thought that's sort of what Senator Lewis is sort of pointing to is if it's someone who's kind of engaging in the worst of the worst, they're probably violating many of the other RFA aspects and for those things could be charged criminally. And I really do think it is different when you are saying you need to do something versus you can't do something. What is the harm being done by someone not completing the course to the victim versus all those other things do harm to a victim, do immediate harm to a victim, whether it's actively violent or threatening violence or showing up where you're not supposed to be. And so I do worry. And I feel like as we're trying to open this up and use this softer approach just makes more sense to me to roll that out. But I also, again, want to hear what the network thinks about this before I land anywhere. I don't think it's up to me or the courts. We should really center the voices of the people representing those most impacted.
Yes, but on the civil route, if you say that it would bring the victim back into the court.
yes, I mean, the way civil contempt happens is the
I'm
court on
familiar with that, yes, but it will bring them back into court, correct?
Yes,
So the victims, we need to take into consideration the victims.
That's what I'm asking for. I'm asking to hear from them.
You have the witnesses that
The party from the network is sitting in the room.
you also said you wanted to hear from somebody with lived experience.
No, I said I'd like to hear from someone who represents those with lived experience. I mean, certainly it would be great to hear from someone, but I can't produce someone at this, with this little time left in the session.
Any other questions or statements for our current witness?
No, I apologize. I didn't mean to cut you off.
No, perfectly fine. I talk. Thank you all very much. Appreciate your time.
Thank you. Charlie, did you want to chime in?
I'd be happy to. Thank you for the opportunity. Charlotte Glisserman, I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. As Kim and Carolyn noted, we also feel like this is a policy decision that the committee could make. We had a really robust conversation in House Judiciary about this piece of the bill. And overall, I think we feel comfortable about where the language landed. If H222 is implemented, the Domestic Violence Council will monitor data on DVAP completion rates, as well as victims' experience going through these proceedings, how it's being received in the courts. And there is language in the bill that directs the Domestic Violence Fatality Review Commission to include that data in the report. So we feel like there is a clear opportunity to see how things play out as they're implemented, and then come back to the legislature if there is a change needed. If this language appears to negatively impact DVAP completion, we can certainly follow up with stakeholders and the legislature. I did ask our legal clinic about Family Court Rule 16 to see if they had any feedback on that. I haven't heard back from them just yet. But that's something that I think I will hear back on very soon and would be happy to follow up by email or in a moment when I get a response.
Great, thank you. Any questions or comments for Charlie? Okay, so I think we will wait on this for a little bit. I'm gonna talk to my counterparts in the House and see what they're see how this would do, change things. It seems like the majority of the committee is leaning towards taking out the lines 7 through 9 regarding the contempt proceedings and having it be formed with the having it be a criminal violation. Am I incorrect in that, or is that the general consensus of the committee?
Oh, yes.
That's where yeah.
Okay, so we
I have a
will.
no on that. I worry about creating more crimes when we don't know what that impact is gonna be. And I would also, as I've asked for in bill form before, want to hear from our director of racial equity as whether or not we think that creating this crime would have a racial impact.
Okay. And what?
Do
I
I?
worry about the victim.
Yeah, I'm also a no, but I'm going to lean on what the majority of the committee wants. So we'll line up some additional witnesses, potentially for tomorrow, or maybe Friday. I'm not going to be here Friday, but you can still listen at. And hopefully we can vote this out promptly.
Nice. I said probably or
Promptly.
Oh, they said prompt or probably.
That would be good.
Probably.
Probably.
We are all